First off, Happy New Year, IP friends, and to everyone listening to me in this new year. Now, we're done with the complimentaries and pleasantries. Let's get into our very first conversation for 2024. While a lot of people were celebrating, coming up with their vision board, New Year resolution, New Year goals, etc., etc., the IP community was gearing up to receive another hot copyrighted work going into the public domain. Now I'm seeing a lot of trademark applications going on. We're going to talk about that later. There's also a movie premiering this year about this one particular work. If you follow me on other social media platform, pretty sure you must have seen or you have an idea of what I'm going to talk about today. But yeah, stay tuned.
IP, IP,
IP,
IP,
IP,
IP, IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Anwari Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys.
If you have been following IP series content or you've been listening to my podcast, you may have heard me talk about term of duration for intellectual property rights such as copyright, trademark, patent, industrial design, plant variety at the moment. For copyrights, we know that it lasts for the lifetime of the creator. So if the creator lasts for say 90 years, 100 years, plus 70 years after he or she has died, the heirs and the successors in title will enjoy the right to commercialize the eligible work or the copyrighted work in question. Um, However, with the star of today's conversation, which is the Mickey Mouse Steamboat Willie copyright, Mischief as a brand, if you recall, I think it was post-pandemic where they created went into a collaboration with Lil Nas and created a Satan shoe, and Nike had to sue. The moralists were not having it. No one was really having it. But they started a countdown of Mickey Mouse going into the public domain 2 years ago. So I'm looking at the screenshot and it reads famous mouse copyright 2 years, 44 months, 10 days, 13 hours, 42 minutes, 40 seconds expires in 2024. Assuming Disney doesn't change US copyright law again. So it says that in the late 90s, Disney lobbied through politics to extend the term of duration that copyright enjoys in the US. They are set to have reshaped the American law just to keep Mickey exclusive, and also extend the licensing on Mickey so that a third party cannot get their hands on it. And as of the 1st of January of this year, Steamboat Willie has now gone into the public domain, meaning that any person can now use the work without having to pay Disney any form of royalty. But within the IP space, there are conversations that people have been, pointing at in relation to the fact that, so I think a couple of persons other than IP practitioners confuse the fact that when we are talking about Mickey Mouse going into the public domain, it's not all of the Mickey Mouse version. It's just the Steamboat Willie Mickey Mouse version that has gone into the public domain. There are questions as to the trademark elements to it, um, and several other things. But we are going to have all of those, conversations today, which is why I am making a podcast version discussing um, what what public domain is. So, other than Mischief Collection, which is like a token called Famous Mouse, um, there is also a Mickey Mouse Trap horror movie coming up or coming out or will be released sometime in March of this year. Um, I mean, I think I saw a trailer. I'm not sure, but what that goes to now tell you is that everyone can now experiment with the steamy boat wheel and not newer version or later versions of um Mickey Mouse. I also saw a publication about a takedown proceeding or takedown notice that was sent to YouTube to take down a creator's work. And I watched a bit of the YouTube um movie. So let's see if I can get who sent that to me. Yeah. So let's see if I can get the link and read it out for you guys. Someone also sent me the link, and I had informed the person that I wasn't rude, but I just said, well, I've seen this, but thank you for sharing. So I do appreciate when you guys send me stuff to check out. Sometimes I've already seen them, but I do appreciate the choice that you guys put me in mind. So it goes Disney backs down from Steamy both Willy YouTube copyright claim. And we know that take down notices or take down proceedings will only occur if um, an IP owner feels that the person who has uploaded the work on the internet or is sharing or distributing the work has does not have the authority to do so. So they can tell the internet service providers to take it down because the work is infringing. So Disney had asked YouTube to take down this publication um, by a YouTuber and voice actor called Brock Baker, who had uploaded a video to his channel, and he had he has like over 1 million subscribers. That is huge. So he gets a message from YouTube saying, "Hi, Brock Baker. Good news. After reviewing your dispute, Disney has decided to release their copyright claim on your YouTube video title Steam Boat Willie Brooks Dub. Thanks, the sign the YouTube thing." So apparently, this video featured the entirety of the 1928 Disney animated short Steamboat Willie. He had remixed the film, used his own comedic audio track playing over nearly 8 minutes cartoon released under the titles Steamboat Willie Brookstone. So these are some of the issues that um public or popular works would get when they go into public domain. I think next year we'll be seeing this other famous cartoon. I'm trying to get to the post, so just give me a minute. Yes, so Popeye the Sailor Man will enter public domain next year, and Larry Zena, who have featured or who has been a guest on my podcast, says, in case you were wondering what horror movie trailer is going to drop 1st of January 2025, and someone says, I've had a Popeye obsession since I was 4 and already have a live action Pirates of the Caribbean tone Popeye script ready to go, and the novelization half written. I just need someone to figure out how to get it in the, I cut that part out. But it shows you that a lot of persons are waiting. So I think, was it, yeah, yesterday I was at my friend's house and her husband was playing Katya's new song titled Baby Piano. And when I heard the lyrics, the first thing I did was to Google, has this song gone into the public domain? And I got my answer. I'm like, okay, that's what you get when your work gets into the public. So I've been talking about public domain, public domain, public domain. What is public domain? You know that Bible passage, sorry if you're Muslim and you're listening to me, where it says there is time for everything. It's a time to live and it's a time for death. So for copyright, it's kind of like the end of an IP, the end of the exclusive right, the end. This is when the law says, okay, we are no longer going to protect you. So it's free for anybody to now copy, share, and reproduce that work without paying you any form of royalty. Using the Mickey Mouse case in the US, Mickey Mouse has been protected for a duration of 95 years. So it's also very important to know that any modern version of the Steamboat Willie Mickey Mouse is covered under copyright. Sorry, any version of Mickey Mouse is covered by copyright, and the Steamboat Willie, which has gone into the public domain, does not enjoy any form of copyright protection. Remember when I was talking about it, I stated that the an IP such as Mickey Mouse can have a multi-layered IP protection. So there's a trademark element where you are not required and you cannot use Mickey Mouse in a way that misleads consumers into thinking that whatever work you've created is sponsored or was sponsored by Mickey Mouse. You cannot do that. When you do that, you're infringing on Disney's Mickey Mouse trademark protection. We know that when we're talking about trademark protects names, designs, colors, um, pattern, etc. Okay. Um, why is Mickey Mouse going into public domain? Mickey Mouse is going into the public domain because its term of protection has elapsed. It expired on the 1st of January of this new year. Now, this also goes to show how valuable works in the public domain can be and how they can be used to promote new creativity, innovation, um, another inspired copyrighted work. There are also conversations as to what elements of the public domain character of the Steamboat Willie version of Mickey Mouse can Disney still be able to protect. So, for instance, the Mickey Mouse that has gone into the public domain has white gloves. Whereas if you look, I think I have a collection. Let me look for that picture. So I have a collection of the versions of um, the works that I've got. The Mickey Mouse design starting from the 1928. So in 1928 there are three. Okay, 1928 there are two versions. One on the Steamboat Willie. Then there's the 1929 version, there's the 1935 version, the 1940 version, the 1953 version, the 1983 version, the 2006 version, the 2013 version, and the 2023 version. So you see that I would say for a brand, Disney has positioned themselves in a way that they end up not losing out so much. So while a lot of people might feel that make the whole Mickey Mouse collection or everything that has to do with Disney and Mickey Mouse is in the public domain. They must take note to understand that the only version of the Mickey Mouse that has gone into the public domain is the Steamboat Willie version. I hope that makes sense. If it doesn't, I'm always happy to engage everyone who wants to talk about this. But moving on, works that enter into the public domain will depend on the laws of the country. So we see that in the Mickey Mouse case, it took 95 years. In Nigeria, it's going to take about 70 years. So it's the life of the author plus 70 years. And some of the common ways could be how the work was created, if the work has expired, if the creator of the work deliberately forfeits or waiver their intellectual property rights, such as making it a creative common work or a public domain dedication, the work, or if the work was created by a government entity or an employee or um, a government entity, basically an employee of a government entity. This will include laws, court decision, or scientific reports. I hope that answers that bit. So, examples of public domain work other than the ones that have expired because of the law would include Wikimedia Commons, Internet Archive, which is like a website that preserves and provides access to digital content such as web pages, books, audios, videos that are either in the public domain or have permission from the intellectual property rights holders. And there's one other one, but I need to confirm. Just give me a minute. Right, so there's Project Gutenberg, which is like a website that offers, it's like a library of over 70,000 free ebooks that you can choose from, mostly literature, anyways. But yeah, I think that's it. How can you use a public domain work or a work that has been created and has now entered into the public domain? Basically, when it becomes available to anyone without any requirement for permission or any restriction, you are now able to copy, modify, distribute, perform, display the work. You can also create new works using the public domain as a foundation, which will include parodies, remixes. So, like we've seen with the Mickey Mouse horror, then I think I saw a post by Larry Zena, where someone had asked him whether to, it's not asked him per se, but he kind of answered the question where it's like, okay, what are the other examples of copyrighted works that have, sorry, of copyrighted work that have gone into public domain that people have reproduced? And he mentioned Les Miserable. I think that's how it's pronounced. Les Miserable, the movie that what's that Princess Diary lady again? And Hathaway. Yeah, I think so. But basically, yeah, West Side Story, Sweeney Todd, Phantom of the Opera, Miss Sargent, Wicked, Into the Woods. I love it. If it's the Into the Woods I'm thinking of, I love the music, the movie itself, and the songs that were featured. Rent, Hayden Stone, Sunday in the Park with George. So those were the ones he listed when Andrew Kaufman had asked the question. So my next question that I'll be answering is, can works get into the public domain before their term of duration expires? And the answer is yes. You may ask me how. First off is if the author decides to gift the work to the general public and say, okay, here, you guys can use my work. I'm not going to create any restriction. You don't need to get or obtain license or get permission to use the work um, from me. So they are basically waiving off their economic right to earn from the commercialization of that work. But what they get to retain is the moral right to prevent third parties from mutilating or distorting the work in question. Another way this can happen is that it is not an eligible work, such as it could be an idea, it could be official text or works created by government employees, um, as provided under the various copyrighted law. I think under our law that is found. Hold on, I need to verify so I don't mislead you guys. Okay, so it's found under Section 3 of the Nigerian Copyright Act, which states that the following are not eligible for copyright protection in Nigeria, and they include ideas, procedures, processes, format, system, methods of operation, concept, principles, discoveries, or metadata, official text of a legislative or administrative nature, as well as any um, official translation except their compilation, official state symbols and insignia, including flags, coat of arms, anthems, and banknote design. So I do recall there was this dispute about an African country's national anthem, whether it could be copyrighted or not. Can't remember the jurisdiction right now, but if I do, gonna let you guys know later. But if you're listening to me and you are aware of that case, please, 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 I would appreciate if you send me a message or a DM just to jog my memory back. So you know that to every rule there's an exception. So there are some exceptions and limitations that may apply to works that enter public domain before their term of duration expires. Also, before I delve into that, um, under the Ghana Copyright Act, the law makes provisions for I think three things someone when a work that goes into the public domain um let's see now, I'm trying to look for that tweet though, because I had to talk about it as well. Just give me a moment, guys. Give me a moment. Right, so under section 38 of the Ghana Copyright Act, the list that works that belong in the public domain would include works who their term of duration have expired and elapsed. I hope that I think I've explained this already. And the second one is works by authors who have renounced their IP rights in writing and made public and shall not conflict with any previous contractual obligations relating to the work. And final, okay, no, third, foreign works that do not enjoy copyright protection in Ghana. And finally, a work that has fallen into the public domain may be used without any restriction. So, while I'm looking at this from the international or the US perspective, and also the Nigerian angle, Nigeria does not have a specific law as to stating this requirement as provided in Ghana. But what the law provides basically is it clearly dictates or stipulates the term of duration that each of these copyrighted work enjoy. So you know that for the life plus 70 years after the death of the author, or in the case of co-authorship or joint authorship, um, the last author who dies and then the work goes into um, the public domain, or if it's for an anonymous work or pseudonymous work, yeah, especially if it's a literary, musical, artistic work, it lasts for 70 years after the year in which the work was first made available in the public with the consent of the author, or 70 years after the work was created, if not made available to the public within that time provided. And like I said, for joint authorship, it's the death of the author. Reference to the death of the author shall be the author who dies last. So it doesn't expressly state that after the work goes in public domain, it just says this is the duration of copyright in Nigeria. So I was going to talk about um, exceptions and limitations that may apply when a work enters into the public domain before their term of duration expires. For instance, where a work may still have other intellectual property rights, as we've found or seen in this Mickey Mouse case, there are still existing trademark that are available. A post by Trademarks are Magic say that someone in Florida last year applied to register Steamboat Willie as a trademark for plush toys, you know, Um, and that's one of the issues when people don't understand that, or when IP owners do not explore explore a multi-layered IP protection. So we need to know that there's a difference between copyright and trademark and patent rights and industrial design or design patents, depending on your jurisdiction, and trade secret. I think the most popular ones are copyright, trademark, patent, and industrial design. Trademark and copyright, according to NE, Mark Death, is that they can overlap, but they each protect something different. Copyright has a limited exclusive period, but trademark can last for as long as the mark is used in commerce. Um, what else? Yeah, okay. Um, it may also prevent you from using the work in certain ways, such as implying endorsement by the owner or modifying a work in a derogatory manner. Remember, I talked about moral rights. Moral right gives you the authority to do that. There are some works that have different public domain status in different countries, so you need to do your due diligence and investigation to ensure that all of that is covered. A work that is in the public domain in one country may not be in the public domain in another country due to different laws and treaties. Uh, so yeah. So next question on my list is, can I use Mickey Mouse and other public domain characters in my work? I think we're already seen that. We already have the Mickey horror movie. We have the Steamboat Willie that was uploaded on YouTube by, I think I mentioned Ned. I think I mentioned the case previously. Then we have the mischief as well. We also have, I think, the US have been seeing a lot of trademark registrations, and people not understanding that there is actually a difference, not a different town hall, but there is. If you're Nigerian, I'm sure you understand what I just did there. But moving on. Um, yeah, things to keep in mind is that you can use, but with some limitation. You can use the public domain version. That's the one that went into the public domain on the 1st of January this year, such as the appearance, personality, storyline in the original work. But you cannot use any later addition or modification that are protected, such as the color scheme, voice, or music of Mickey Mouse in the later cartoon. You can also not use any trademark or logos that are associated with these characters, such as the Mickey Mouse ears or the Disney names. And things that you need to keep in mind when using a public domain work will include that you should learn to give proper attribution or acknowledgement to the original author or source of the work. Be aware of the different type of intellectual property law that apply to public domain works in different country. I just read to you guys section 38 of the Ghana Copyright Act. You should also be careful not to infringe on any other intellectual property right associated with the work, such as trademarks. We know that trademark as an IP acts as a source identifier as long as you use it consistently in commerce. It must be consistently used in commerce. Um, you can also use the public domain Mickey Mouse from Steamboat Willie to imply endorsement by Disney or to create confusion with their trademark. I hope that answers. Yeah. Now, in the course of all this public domain conversation, I decided to talk about the difference between what the public domain work is, what is Creative Commons works, and how it will apply. Remember, I talked about how um, you can. Apologies, guys. I just read something now. I talked about how you can use some works with certain um limitation previously. I think if I listen to segments before this one, yeah. So what's the difference between public domain works, Creative Commons works, and open source work? First off, public domain works are works whose IP protection has elapsed. Their time of duration for enjoying the full backing of the law has elapsed and can now be used by anyone for whatever purpose without permission. So as the work elapses, both the economic and moral right goes with it. So the owner of the public domain work, or not, there's no owner right now. So the work in the public domain, someone cannot come and say, oh, you're distorting or mutilating like the Mickey Mouse now has a horror version. I'm pretty sure that when the Steamboat really was created, no one was thinking of what's the word now? Mutilating it. And I know that Disney would not have um stood for that. They would have opposed it with all that they had. But right now they cannot do anything about any version that's coming out because it is it has gone into the public domain. I'm going to also talk about something else. I think I mentioned it at the beginning of my introduction when I talked about how Disney was able to stay this long in the United States. Then you have Creative Commons works that are used um, for works that are protected by IP rights, but the owners have chosen to give permission to other people to use their work under certain conditions. Now, Creative Commons is a non-profit organization that offers six standardized licenses for sharing creative work such as writing and multimedia. So I had shared a link on Twitter when I was talking about it, but I'm just going to read the licenses for you guys so you are aware. So you have the CC BY, which is a license that enables users to distribute, to remix, adapt, and build upon any material in any medium or format, as long as attribution is given to the creator. So this license allows you to commercialize the work. So you see a circle with an image, not an image per se, but human like uh, what's it called, an emicon, and then BY. So credit must be given to the creator. Then you have CC by SA. This allows you to distribute, remix, adapt, build upon the material in any media format. You can also use it for commercial purpose, but you must include that credit. Credit must be given to the author. They have CC by NC. Still allows you to distribute, remix, adapt, and build upon any material. Um, must be used for non-commercial purposes only. As long as you give credit, you acknowledge the author, you're good to go. Then you have CC by NC and hyphen SA. So by credit must be given to the creator. NC only non-commercial uses. SA adaptation must be shared under the same terms. Then you have CC by ND, which is credit must be given to the creator. No derivative or adaptation of the work are permitted. It's also going to be used for commercial uses only. Then you have CC by NC hyphen ND, which is credit must be given. Only non-commercial uses of the work are permitted. No derivative or adaptation of the work are permitted. So there is the CC0, which is like a public dedication tool that enables creators to give their copyrights and put their works in the worldwide public domain. It also enables users to distribute, remix, adapt, and build upon any material in any medium or format with no conditions. So you can just check out the creativecommons.org website and read all about the licenses, how to apply for it, what to do, how to choose a license, and any other information that you may require. And last but not the least is the open source work, which are works that are protected by intellectual property rights by the owners, um, but they have chosen to give some permission to other people, give permission to other people to use, to modify, and distribute their work under certain conditions. Open source is a term that usually applies in relation to software. I mean that softwares are eligible work Um, but it can also apply to other types of work such as hardware and data. How can you determine if a work is in the public domain? First, check the source and location of the work. Check the publication date. Check the license and permission of the work. And then, how do you get to use an expired copyright work that is not in the public domain? Work with an expired copyright are free to use without permission because the author's exclusive rights have ended. Exceptions or limitations may apply based on the type, date, and the region of the work. And also, some works may have different public domain status in different countries and jurisdiction. So, do your findings, make sure that you are not um, doing anything illegal. So, what are the benefits of using a public domain work? What are the benefits and risks? Benefits basically are that you have access to a rich catalog of content. It can act as a source of inspiration and creativity. But the good thing is you're not paying any form of royalty or stipend or money in order for you to use it. The risks are that you may face legal challenges or dispute from the original owners or their heirs or successors in title, who may claim that you are infringing on their right or diluting their brand. You may also face ethical or social criticism from the fans or the public, who may accuse you of plagiarism, disrespect, appropriation. We're in the era of cancel culture where it's easy for anyone to just post something. I think it was a SpongeBob SquarePants case. I talked about it last year, last 2 years now. Cannot remember, but you can check out the episode where I discussed that in detail. I'm trying to let me remember how the case went. Yeah, so it was the Justice for SpongeBob fan made version that was struck down. So Paramount Pictures and its partner pulled down a fan made version of the SpongeBob SquarePants movie Rehydrated. And the tweet that went out was Paramount hates everyone took this lot 2 years to make in honor of Hillenberg. So hashtag justice for um SpongeBob, and they were claiming fair dealing. So I think I should talk about fair dealing. Fair dealing basically means you're using a copyrighted work without the intention of making profit from it. So under the new Copyright Act, the Nigerian Copyright Act, Section 20, which talks about the exceptions under the Act, lists instances where the court will say, okay, I do not think this party had the intention of infringing. So, if you're using a work for your private use, for parody, for satire, caricature, non-commercial research, private study. You're using it to criticize, to review, to report current events, subject to the condition that if the use is public, and where practical, there must be an acknowledgement of the title of the work and the author, except where the work is incidentally included in a broadcast. However, this is the exception now, where provided that in determining whether the use of a work in any particular case is fair dealing, these following factors shall be considered by the law. First, the purpose and the character of the usage, nature of the work, the amount and substantiality of the portion used in relation to the work as a whole, and effect of the use upon the potential market or value of the market. It goes further to list other factors such as the inclusion in an audiovisual work or broadcast of an artistic work situated in a place where it can be viewed by the public. The incidental inclusion of an artistic work in an audiovisual work or broadcast, quotation in the form of short excerpts from a work, reading or recitation in public or in a broadcast, not for commercial purposes, um, or any reasonable extract from a published literary work, as long as there is an acknowledgement of the title of the work and its authors, then any use of the work by or under the direction or control of the government or by such public libraries, non-commercial documentation centers, or scientific or other institutions as may be described, um, where the use is in the public interest, provided no revenue is derived, the use does not substantially affect the potential market or value of the work. Then you have the reproduction of the work by or under the direction or control of the broadcasting organization, where the reproduction or any copies are intended exclusively for lawful broadcast and are destroyed before the end of a period of 6 months immediately. See, as I stress that immediately, it's very important. Following the making of the reproduction, and then you have if it's an exceptional documentary character, it will be preserved in the archives of the broadcasting organization, or it shall be used for any other purpose without the consent of the copyright owner. Lawful broadcast in this case will mean a broadcast that does not infringe on the copyright in the work. Then, news of the day for public broadcast or publicly communicated by other means. Any use made of a work for the purpose of judicial or legislative proceedings or the reporting of such proceedings. I think we saw a lot of that during the election petition period where people were giving live reports or their own interpretations, or how would I put it now? Basically, they had a lot of Twitter's currently X users that were interested in the presidential election petition, and so if you really wanted to know highlights of the day, what was going on, I think this news of the day for public broadcast, uh, purpose of judicial legislative proceeding or the reporting of such proceedings. So the reporting of such proceedings, what happened in courts, what the court said, and also other newspaper or blog publications. Then you also have what's it called now? Let's see. Reproduction for the purpose of research or private study of an unpublished literary or musical work kept in a library, museum, or any other similar situation. Um, Without prejudice to Section 26, which is the special provisions for beneficiary persons, people that are blind, deaf, and visually impaired. Um, the use of artistic work in the form of building models or a drawing or plan of building for the purpose of reconstructing the building, communication or making available of works and other materials not subject to purchase or licensing term to members of the public for the purpose of research or private studies through dedicated terminals on the premises of publicly accessible libraries, educational establishments, museums, and archives. Capiche? Yeah. Then sub 2 now says, notwithstanding section 9, which is basically talking about the exclusive right provided for literary and yeah, for literary and musical works now. I sabi the thing. Sorry guys. You know, sometimes it gets a bit confusing, but this is I'm not supposed to be confused about that. 9 is for literary, yeah, literary or musical works. So let's go back to section 20, sub 2 now. So it says, notwithstanding the provision of that, the reproduction of a copy or the adaptation of a computer program. Remember, I talked about softwares, right? Yeah. And then when I was talking about open source, um, the reproduction or adaptation of a computer program is permitted if the copy or adaptation is necessary for use with the computer for the purpose for which the computer program was obtained. Archival purposes, the activation of a machine that lawfully contains an authorized copy of the computer program. Um, and then sub 3 now states that any contractual term which purports to restrict or prevent the doing of any act permitted under this act shall be void. So I think it was because of the justice for SpongeBob that I delved into further. But I hope with these few points of mine, I'll be able to convince you and make you understand further the differences between what fair dealing is, public domain works, open source, yeah, and Creative Commons, and also looking at the benefits and risks of when a public domain when you're using a public domain work. So for anybody who is considering trademark, please dead the idea. If it's not um the steamy boat element, please just forget about it and just be more creative. So in wrapping up, we will be taking a look at the legal and ethical issues surrounding public domain. First off is that the extension of copyright terms. So if you recall, when I was reading about the Mickey Mouse story, which happens to be a copyrighted work in the United States, Disney had been able to successfully extend the duration of protection for Mickey Mouse, thereby delaying its entry into the public domain. So I think 2 years, this is 2024. So 2 years ago, when the conversation started, and people were like, "Oh, Mickey Mouse is about to go into the public domain. Let's see what Disney is going to do. Let's see what Disney is going to do." And this was it. And it was seriously criticized because it limited access, um, and also prevented people from using the works. And it is alleged to have um, benefited the large corporations such as Disney rather than individual creators. You will see that Disney went ahead to create other versions because I guess they kind of expected that pushback that if it got to 2024, people may not be open to seeing them extend the term of duration of the Mickey Mouse team both will. Then the second one is the protection of moral rights. Moral rights, like I previously stated, are so let's look at it from the Nigerian context, and that is found under section 14. So I'm trying to get to the act so I can it verbatim for read it verbatim for you guys. My phone is messing up right now. Just give me a second. Yeah. So section 14 reads as follows. So it says author's moral rights. The author of a work in which copyright associate has the right to claim authorship of his work, in particular his authorship in connection with any of the eligible work as listed from section 9, 10, and 11, except where the work is incidentally or accidentally included in a broadcast when reporting current event. Exception. Secondly, the author of the work have the right to object and seek relief in connection with any distortion, mutilation, or other modification and any other derogative action in relation to the work where such action would be or is prejudicial to his honor or reputation. Sub 2 says the person has a right to object to what being falsely attributed to him as the author. And now, most important is that this right cannot be transferred during the life of the author, and upon his death, it will only revert to um, his successors in title. and shall only last for the duration of the copyright. So the lifetime of the author plus 50 or 70 years as provided under the act, and depending on the type of intellectual property or copyrighted work. Shikina, that's it. So for instance, it is stated that in France, moral rights still lasts even after um the works have entered into public domain, which means users of public domain works may still need to obtain permission from the authors or their heirs to modify or adapt their works or use them in certain contexts. Um, and it's bringing up issues in terms of restricting freedom and creativity that users of the work are supposed to enjoy once a work goes into the public domain. So I know that every first now we're going to get publications. I think next year proper year is going to go into the public domain. We're going to go through this whole run. I think it wasn't other works have not been controversial because I think the owners have not done what Disney had done in terms of extending and the term of duration. But I guess we'll just have to get used to the fact that whatever has a beginning has an end, and we just have to learn to let go. So, for every 1st of January, if you're a bit confused about what public domain are, come back to IP series and listen to me discuss about the facts and frequently asked questions when dealing with public domain works. You know, a license is when the author gives an individual or multiple people the right to use work either through a single license or exclusive or non-exclusive license. Display a clear notice on the new work, which includes the title and author, the license of the work, the source and status of the public domain work, any changes, and then if you register the work with the relevant authorities such as the US Copyright Office or the Nigerian Copyright Commission, as the case may be. Registration can provide you with additional benefits such as a public record of your ownership of the new work and creation date, a presumption of validity and originality, um, possibility of statutory damages and lawyer's fee. See, I'm smiling about that. Yeah. Um, you can also monitor and defend your new works against infringement. You can monitor the internet and other platforms for potential infringement. You also have the right to now contact the infringers and request them to stop and remove the infringing work and comply with your licensing term, or you can reach out to the internet service providers to help you with the takedown proceedings. You can also reach out to the commission if it's in Nigeria to work with customs, depending on the work in question, whether it's a literary work or whatever it is. You can also get legal advice and assistance if the infringer does not cooperate with you by speaking to an intellectual property lawyer versed in copyright or a law firm versed in intellectual property and copyright related matters. Um, these are some of the basic things that you can use to now protect your own rights, such as the owners of the Mickey Mouse horror movie and Mischief Collection slash Token and every other work that will be seen going forward. So I hope that this episode helps you understand the public domain and how it affects you as a creative professional. Facts, queries, whatever it is. If you have any question or comment, please feel free to share them by sending me a DM to at IPSERIES with Esmeralda ESQ or an email to IPSeriesinfo@gmail.com. And if you found this episode useful, please like, subscribe, and share it with your friends and family. Thank you, IP friends, for listening. Thank you for all my new listeners. And cheers to more exciting episode in 2024.